Hi, so we will be starting a very important topic, that is your constitution and the labor laws. Now when we talk about the constitution of any country, it is the basis, it forms the basis from which all the other laws are made. So constitution actually creates the fundamental laws of the land. Now when we see constitution and labor laws, the labor laws in India also derive the powers from the constitution. It derives its powers from the preamble. When we see and read the preamble, you will see the word, it talks about giving the people social justice. So giving, uplifting all the members of the society is what is there. The part 3 of the constitution talks about the fundamental rights, and part 4 of the constitution talks about the directive principles of state policy. All this we will see, and how these three things are used to make and form the labor laws which are there in India. The constitution actually is the basis for all the authorities, and all the authorities derive their powers from the constitution, whether it be the courts, whether it be the parliament, or whether it be the enforcement agencies. They all derive their constitution and have to act according to the constitution. In India, the constitution divides the powers of various governments, the various governments into 3 lists. There are 3 lists: list 1, list 2 and list 3. This is given in your article 246 of the constitution, read with schedule 7, which says that the powers of the government are divided into 3 categories. The list 1 gives you all the items, all the matters on which the central government can make the law. Whatever is given in the list 2, that is all the the state government can make the laws. And whatever is given in the concurrent list, both the center and the state can make laws. This we know. Now my question is, the labor laws falls under which list? Labor laws falls under which list? List 1, that is whether you will have only central laws or the state government, that is only state, each state will have their own labor laws, or we have a concurrent powers where the state and the center both can make laws. So the answer is, labor is a subject of concurrent list. So both the center and the states can make laws with respect to bearing on the industrial laws and industrial relations. Now what are we seeing is where all the constitution is giving powers and guidance and duties on the state to ensure ensure a fair labor practice in the country. So first, my question to you is whether the labor laws of any country will be labor oriented, that is, it works for the benefit of the laborers, workmen, or it will be business centric, business oriented. What do you think? Will it help the laborers, workmen, or it may help the businesses? I want you to answer. Exactly. If you're saying that the labor laws will be labor oriented, then let me tell you, there is a surprise that globally that is not the case. Globally, all the countries do not follow labor oriented labor laws. Some follow the business oriented, where all the laws are mostly in favor of the business owners. In India we know that the labor laws are labor oriented. You will see it's a labor oriented legislation, labor welfare legislations, which you will see. So mostly the favoring will be on the labor side. But if you go to see countries like USA, countries, or you could say places like Dubai, UAE, or countries like Singapore, okay, or you could say even the UK, they have businesses oriented. So all the labor laws are business friendly and not labor friendly. Now, why is this and what is there? So when we talk about labor laws, you have to understand whether the country is a developed country or it is a developing country. See, understand the logic. If and whether there is a labor surplus in the country, if there is a labor surplus, or if there is a labor deficit. See, whenever there is a labor surplus, the business owners can misuse their powers, where they will say that, listen, we want to if you are not working, we'll keep you anyone else. If there is a huge unemployment, they will say, if you don't agree to our terms, then get out. So in that case, which is the case of India, in India it's a labor surplus country. So we have to say that, listen, the business owners have lot of supply of laborers and lot of options, so they might misuse, and therefore we have made labor oriented laws. When you go to business oriented, you will see all the countries which have less population or want to, like a country like Dubai, it actually wants to internationally drive businesses in the country. So when will a business come? When they know that all the laws are favoring them. So they want businesses to be set up in their country. So then they will say that, listen, we'll make in our thing. Or if there is a labor deficit, they know that the laborers have stronger bargaining power because businesses are not getting anyone. So they will put down their terms that, listen, I want XYZ things, otherwise I will not come to work. So therefore, seeing the entire economy, the whole structure, the labor laws of any country are developed. So always you will see that it will be trying to balance out, okay, they will try to keep a balance, keeping the social objectives in mind, okay, and the conditions and demographics in mind. Now, so this is what they are saying, that industrial relations is very important for any country and the society and economic goals. So industrial relations, where the businesses have their contact with the laborers, so entire society is based on that, right? Society benefits, you could say the families will be happy. At the same time, we will get more revenue, more production. So it has to be very well balanced. How much states intervene, okay, will be determined by the economic development. So it depends on which stage are you and what is the surroundings of your circumstances. According to the labor laws are developed. In developing countries, which I told you, like USA, Singapore, okay, it is left to the people, okay, they are left to the employers and the workmen, and you all settle it. Try to resolve the disputes among yourself. Both of you all are strong enough to decide. Laborers there are not that weak. Conversely, in developed countries, okay, where there is a surplus of laborers who are not educated, then we have to be, the states will have to step in and states will have to come and protect, which is the case of India. Now, Indian constitution is actually a welfare constitution. It has a vision of welfare and federalism. Federalism is when there are two states, all the powers are divided. So that we know is there. But also it is a welfare oriented, where we try to meet the economic as well as the social objectives should be achieved. And that is what the constitution has envisioned. Labor relations are represented in 3 constitutional lists, which we have seen, and that is your concurrent list. Labor laws in India, we will see that there were multiple labor laws. Now you have the labor codes which are there. From the constitution point of view, I want you to learn this and quote it in the exam. This is the entire summarization of all the labor laws, powers derived from the constitution. Okay, so we will see, and If you have done your Constitution of India, you will be able to relate with it much more. Even if you haven't, no problem, I will make you do it now. So now we are seeing the highlights. Then when we progress later, we will cover all of this. Article 14, I want you all to tell me what it is. Very good. Equality before law. Everybody knows this. Article 15, discrimination. There was a movie also called as Article 15 where there was discrimination on the basis of gender, religion, caste, the place of birth, etc. So this is prohibition on discrimination. Article 15. Article 16 talks about equal opportunities in public employment. This is where the labor laws, because Constitution in Article 16 is saying that you have to give equal opportunities to men, women, and no discrimination on the basis of religion. Then comes Article 19(1)(c). What does it talk about? Article 19 is about freedom, and 1(c) talks about freedom to form association. So from here the trade union get their powers. Trade Unions Act or trade union get their powers. Article 21, right to life and liberty, because living a good life is one of the essential elements of right to life. Article 23, what does Article 23 talk about? In many manufacturing units, you will see that they're doing child labor. There is cases of harassment, of traffic in human being, buying and selling, forced labor. So obviously the Constitution has prohibited it, that prohibition of traffic in human being and forced labor. Traffic in human being means buying and selling of human beings as you do of goods. So that is also prohibited. Forced labor. Article 24, prohibition of employment in factories. As we saw, Article 23, 24, both about not forcing people to work and not forcing or not having children to work in factories. Then comes Article 38, state to secure a social order for the promotion of welfare of the people. So here you see we are talking about welfare of the people also. That is why we are saying that the Constitution envisions welfare of the people. It's a welfare oriented Constitution. Article 19, this you have to know and have to quote, and this definitely I believe you must be knowing. It's one of the most prominent articles of Part 4 of the Constitution, that is your directive principles of your state policy. Article 41 talks about right to work. So every person has a right to work, get assistance, right to education. Article 42, that you should give just and human conditions and maternity relief. So you have your maternity if during pregnancy women have a lot of benefits. That act itself is deriving its power from Article 42. Then comes 43, living wages. We will see what is living wages, that you have to give where they can live and enjoy their life, work-life balance. 43A talks about participation of workers in industry. So in industries, we want that workers should come up, give their thoughts. This is what Article 43 has envisioned. Article 32 and 226 are nothing but your writ. Whenever the fundamental rights are violated, the writs can be filed in the High Court or in the Supreme Court. In the Supreme Court, you will go under Article 32, and in the High Court, you will go under Article 226. Okay. 227 talks about power of superintendence by the High Court. The High Court has a power to supervise all the working of the courts below it. So like how you have a senior looking over a junior. So power of superintendence over all courts by High Court. Article 136 is, if you are unhappy from the High Court, where will you go? So obviously you will go in appeal to the Supreme Court. This power is mentioned in Article 136. Appeal to the Supreme Court. For going in appeal, you have to take a SLP, that petition is called as special leave petition, where the High Court writes that there is a certificate of fitness that yes, this matter is of national importance, a public of law, a point of law is involved. So I'm giving, you can go a special leave, a special permission is given by the High Court to appeal in the Supreme Court. Now, so we've discussed all the articles and points which are connected from the Constitution. Now we'll go in depth. Social justice and industrial laws. So let's see which it talks about. Indian Constitution, in its preamble, we saw in the preamble also it says secure for all its citizens justice, social justice, okay, as an economic justice as a primary goal. Article 39, the Directive Principles of State Policy, says that it's a duty of the state to apply certain principles to ensure social justice. Now my question to you is, again they will say social justice, we'll see what do you mean by the term social justice. Okay, so let's see. Social justice according to you simply means that there has to be fairness in the society. It shouldn't happen that the rich become richer and poor become poorer. Rich are exploiting the poor. The rich are putting barriers for the poor to enter into business. So that shouldn't happen. So social justice means the society should work in a fair and transparent manner. It doesn't mean that you take the money of the rich and give to poor. We are not talking of equality of income among everyone. Okay, it obviously we are giving that who works harder, who is more talented will earn more. But we are just saying that unnecessary, unfair barriers should not be there. That is social justice. So we will see as per the various cases what they are saying. In the state of Mysore versus the workers of gold mines, that importance of social justice is vital to uphold the rule of law and principles of welfare state. So do you agree that social justice, okay, just talk about whether it be justice, okay, social, economic, but justice is necessary to uphold rule of law. If we are saying that the country will not be governed by the police rule that anyone can do anything, it will be by a rule everybody will follow, rule of law and welfare. To ensure this, to ensure rule of law and to ensure welfare state, justice has to be there. Let's see, in K.N. Bhattacharya, in his work, okay, India plans a generalistic approach, explains that in economic sphere, economic justice means, now according to them, I told you what is my logic of economic justice, that everything should be fair and everyone should have equal opportunities. Social justice means opportunities in greater measure to the poor. There has to be opportunities in greater measure to the poor and needy for their betterment and economic conditions. Okay, so social justice also means that if someone is at a disadvantage, we try to ensure by giving them specific reliefs, or SC, ST, OBC quotas are there, okay, reservations are there, just so that they come back to equal opportunities are given to them. It does not mean just take from the poor and give it, take from the rich and give to the poor. It does not mean about wealth redistribution, that everyone's wealth should be taken and redistributed equally. But we are talking at least there shouldn't be people who don't get even basic necessities. Okay, and it is not only the responsibility of the state, but of the state and the citizens to work for social justice. So remember, in the exam they can ask you a question on social justice. So you can write about the constitution, where all it is mentioned in the constitution about social justice, and few cases explaining the meaning of social justice. Let's see one more case. Chandradhar Jha Judicial Review Legislative Act. The state has a constitutional responsibilities. Agreed? Yes. And citizens don't have constitutional responsibility, but at least a moral responsibility to ensure that we create an ideal society that we can work in. People should feel that there is higher standards of living, there is opportunities of all, there is huge growth opportunities, and that's how what is thought for India. Industrial laws are economic and social justice oriented. Agreed? Yes or no? What is the line? That the laws in India are also justice oriented only, and which is absolutely correct. You go to see the any laws which were there also, the maternity benefit or the state insurance, workman compensation, PF pension fund, this your PF fund, all of this is what? To give economic and social justice only. Okay, so industrial dispute, compensation act, everything by inherently all the Indian labor laws which were there or which are there presently are all embodied in the principle of social justice. You can also mention that the industrial jurisprudence means the study of law. So study of the industrial labor law have founded that on basic idea of social economic equality and aims to remove economic social disparities. This is a very beautifully written line that both positive and negative is being spoken, that the Indian industrial jurisprudence is one about giving social economic equality and negative concept also, removing of social economic disparities. The differences are to be removed. Now social justice, while prevalent across legislation, is especially evident in the industrial laws. Agreed? Okay, it's the objective is to uphold the social economic equality, remove the disparities, resolve the conflicts, all in a fair and balanced manner. By doing so, by ensuring social justice, we will be able to ensure that there is a ensures societal betterment and promotes national advancement. Any country, if you go to see, you can make out whether it is a progressed, whether it's a developed country or no, by the standards of living. Okay, by how much per capita income is there, how much is one person earning, whether they can meet, and how many are there below the BPL, below the poverty line. Okay. Now constitutional limitations, very simple. When we say constitutional limitation, means what? No law can be made against the constitution. Everyone has to be within the constitutional limits. So this is the boundaries are set. Any law which is taking the fundamental rights or is against the ethos or against the preamble of the constitution will be declared void. So this is the boundaries, limitations. No person can step outside of it. Okay. The state cannot make laws inconsistent with the fundamental rights. All the laws that contravenes the fundamental rights are void. Now, let's say for example, there was a law that was against the constitution. What you will do? Or there was a law which you are finding that your fundamental rights are getting violated. What you will do? So this, I am very sure you know that you will file writs. Okay, you will go see, there is an application to the court that you can make that your fundamental rights are violated. So whenever your fundamental rights are violated, infringed, you can go to the court. When you go to the court, you will file an application, a petition that my fundamental rights are violated. That petition is called as writs. There are different kinds of writs depending on which fundamental right was violated. Now, writs, you can go to the High Court or you can go to the Supreme Court. In High Court, you will go under Article 226. In Supreme Court, you will go under Article 30 days. Okay, and if there is an appeal from the High Court, if you have gone and you are unhappy with the decision of the High Court, you want to go to the Supreme Court, you will go in a concept called as appeal. Just like you can go in appeal in other courts, from a lower court you go to the High Court, the same is not there on Supreme Court. Let's see, what do I mean? Okay, now pay attention that when there is a lower court, and from the lower court you will go in appeal to the High Court. So you can directly go, law has given you the powers. But from High Court to Supreme Court, you cannot just go. There is a permission of High Court required. That is called as SLP. You have to ask the High Court only, can I go in appeal against your order? So High Court will not say for case of ego that no, you cannot go. High Court will see that, listen, there is a very substantial matter of law involved. It can have a very major impact, so they can give a certificate of fitness. That is called as special leave petition, that I'm giving you the permission. Go up. That is given in Article 136. Understood? It's a right to appeal given by High Court to the person that you can appeal in the Supreme Court. If High Court has refused the SLP, then there are also powers given to the Supreme Court where they can directly take up appeals. Clear? So these are all your powers which are there. And High Court always keeps under Article 227 a superintendent. If there is any lower court which is not acting or violating fundamental rights, High Court can supervise it and pass orders as they deem fit. Appeal from the decision of the High Court are made under Article 132 and 133, and a special leave petition, that petition is given in 136. Now few very baby case laws they have given you. Okay, can a trade union move the High Court under Article 226? Okay, for the violation of fundamental rights of its people. What do you think? Let's see, there is a trade union. Okay, there is a trade union. The trade union have multiple members. Now they have multiple members. Fundamental rights are violated. Fundamental rights are violated. So can one go to the High Court or Supreme Court? See, normally if his fundamental rights are violated, he will go to High Court, Supreme Court, allowed. But there was a case law that the trade union wanted to go, that collectively everyone's rights are violated. So we want to file a collective application, and High Court, Supreme Court, can they take up the matter that a trade union is coming? So the answer is, obviously I told you in India it's a welfare oriented, labor oriented legislation. So you are allowed, even a trade union can file an application. If they realize that the people want to collectively file, they feel scared, okay, or they don't have the legal knowledge, or they are socially disadvantaged. So they will go under the head of a trade union or NGO also. Fundamental rights are violated. So can a trade union move the High Court? Answer is yes. So what did they say, that can a trade union go to the High Court to redress, to solve the fundamental rights issues? So in the case of Jaipur Division Irrigation Employees versus State of Rajasthan, okay, what happened is, I gave you the answer, okay, yes I gave you. Now there was this case of Jaipur irrigation employees where they found that they just removed the employees. They said that there is a labor surplus, we don't need the people, bye, no need to come tomorrow. So the Rajasthan High Court faced with the issue when numerous employees of irrigation department were declared surplus, you are excess, please go away. Who filed the case? The trade union filed the case that all these people have been removed. Okay, they said that the High Court, the question was raised that this trade union don't have locus standi. Don't have locus standi. Locus standi means right to move the court. The individual member should come, not the trade union. The right to file a case, wrong person is coming. We did not do anything wrong to trade union. So then the court held that listen, and in the SP Gupta versus President of India, they also spoke about the locus standi, who has a locus standi. So they said that listen, a violation of the constitutional right, affected person can come, or any person representing the affected person, whether it be a trade union, NGO, can come. Okay, because these people could not come due to poverty, social disadvantage, they cannot come. Then any person, any public member can file an application in the High Court or the Supreme Court. So the locus standi has been broadened. Locus standi means right to file application is not only the citizen himself, but also a union representing the citizen. That is also allowed. Now, fundamental rights and industrial relation. Now, fundamental rights, I am asking you, under which part of the constitution it is given? So this you need to quote in the exam. Okay, so learn it by heart and quote it in the exam. Almost everyone will know this, that the fundamental rights are from Article 12 to Article 35 under the Part 3 of the Constitution. And Part 4 talks about the directive principles of state policy. So let's see. The Constitution of India, if I see the Part 3 and if I see the Part 4. Okay. Part 3 talks about the fundamental rights. Part 4 talks about the directive principles of state policy. Fundamental rights are given from your Article 12 to Article 35. Okay. Now, understand one thing, that fundamental rights are your basic rights. If these get violated, okay, if fundamental rights are violated, you can file writ petitions in court. Directive principles of state policy cannot be filed. So these are enforceable in court. If anyone doesn't give you, you can enforce it. Go to court and tell that my fundamental rights are there. Please ensure that my fundamental rights are given back to me. So it is enforced by courts. The directive principles of state policy are not enforceable. You cannot go and say that I want the directive principles of state policy. Then why it is there? It is just certain guidance, okay, philosophies given in the Part 4 which the states should try to achieve. It is the most ideal. Part 3 gives you the most basic things which has to only be given. Part 4 talks about topmost things which we should try to achieve. Okay, so states will try to achieve the Part 4 of the Constitution as well. Now let's see with the Part 3 first. Article 14, right to equality before the law. So it says, Article 14 says that the state shall not deny to any person equality before law or equal protection of the law within the territory of India. So let's break it down. First, my question is, does Article 14 apply to citizens or to everyone? Okay, I want you to answer that. Does Article 14 apply only to citizens or to even non-citizens? Can a foreigner claim that he was not treated equally? Answer is yes, a foreigner can also claim. Why? Because if you see, the state shall not deny to any person. Any person means citizen, non-citizen. When you go and see Article 19, it clearly says there is freedom given to citizens only. Article 14 is more wide, says that no person within the territory of India should be denied two things. Cannot be denied two things. One is equality before law and second is equal protection of the law. Equal protection of the laws. So what does the equality of law mean? So let's see. Article 14 has two parts. One is equality before the law. Okay. equality before the law is a negative concept. It is a negative concept that the state shall not deny to any person equality of the law. That equality before law prohibits, you should not discriminate. So when I say I'm giving you equal status, means I'm not discriminating and giving someone else more rights. So you should not deny equal status to anybody. So it prohibits. So since that prohibit word is there, it's a negative concept. Should not do discrimination. Now when I say equal protection of the law, so now we saw equality before law. It prohibits discrimination, and it is talking in the negative sense that don't do discrimination. And equal protection of laws also is the second thing. So this is the first thing and this is the second thing. Equal protection of the law means it's a positive character that requires the state to give special treatment to persons in situations in order to give equality to everyone. It says that, listen, to give equal protection, if someone is disadvantaged, please give them more rights, special treatment, so that equality can be done and equal this can be done. Clear? So when we see a prime minister, now prime minister gets Z class security. Okay, why? That is also coming under Article 14 only, equality. Now how equality when prime minister is getting Z class but you are not? So the answer is, it talks about giving. You give special treatment to persons in different situations, because you are a normal citizen, he is the prime minister or president. So what happens is their lives are more at threat. So therefore in some cases you give special treatment. Similarly for SC, ST, women, we need to protect. So this talks about positive thing, giving special treatment. That is equal protection. Now there was a classic case of Air India versus Nargis Mirza. Okay, very important case, and extremely important. Sure it comes in the exam. Okay, not only in your CS, CA, CMA, but also in your law, LLB. Nargis Mirza. It was a classic case of Indian Airlines, where Indian Airlines made such a filthy and ridiculous rule. So these two were very dirty rules which were made. You will be shocked when you will read that what was the rule. Regulation number 46 and 47. It said that air hostesses, spoke about air hostesses, that air hostesses will retire at age of 35 or on marriage within 4 years of service, or on first pregnancy, whichever is earlier. So if they got pregnant, they will retire. Okay, retire from service. Or if they attain 35, so they will say, what are you trying to say? That if a person is attained 35, let's say 37, 38 years old, so you want to remove them from work? This was the law. And so this was very sad rule which was there, 46, 47. But still the embarrassment continued, where they said, but if the managing director has a right, discretion, to extend the retirement age by 1 year, so now you have to please the managing director so that your job is safe. So this was considered extremely wrong, unconstitutional, and was removed, because we are seeing that we require equality in work, fair opportunities as per our constitution. So the retirement of the air hostess on the ground of pregnancy was unreasonable, arbitrary, and violation of Article 14. Similarly, in NSDS Nakara versus State of versus Union of India, the court underscored means underlined or highlighted, the classification of differential treatment must stand on rational grounds. Otherwise, it is a violation of equality. So if you're doing differential treatment, it should be on reasonable grounds. Okay, so we have seen that Article 14 permits classification but prohibits class legislation. There is a very important saying that, listen, we are permitted to do classification, that is on reasonable grounds, sensible grounds, where we say SC, ST are economically backward, have been backward for many years, so we have to give them special treatment so that they can be uplifted and brought to at equal level. Women are more subject to harassment, so therefore we have to give them more amount of protection. So there, wherever there is rational, logical grounds for protection, we can do this kind of classification and protection. So Article 14 done. Part 3 of the Constitution. Next is Article 16. Equal opportunities in the matter of employment. Many persons don't know Article 16 only. This is a direct power of labor laws is derived from this only, Article 16. What does Article 16 say? The equality in opportunity in public employment. So this is Article 16. Now Article 16 has 5 points. Article 16, when you go to read, it will have 5 points. First, they will say equal opportunity. Principle of equal opportunity. That all the citizens should be given equal opportunity to excel in any appointment or in any particular job of the government. So in government job, equal opportunity should be there to all the citizens. Second point talks about discrimination, that you cannot discriminate on the basis of anything. Okay. Then comes parliamentary provision on residential requirements. Now this is very interesting point. Normally if you would have read, you wouldn't understand. Okay, if I just read through quickly, then I will explain that nothing in this article, Article 16, shall prevent a parliament from making a law in regard to an employment of or appointment to any office under the government, any requirement as to resident prior to employment appointment. So normally you would have not understood, but let me tell you what they are saying. That Article 16 is permitting the government or the parliament to create any kind of residential requirement in a government job. That means they can say that, listen, if we are talking of Rajasthan, so we can say that if we are talking of any post in Rajasthan, we can say that anyone residing in Rajasthan can apply. So example, Parliament could decide that only those who have resided in Rajasthan for 5 years can apply for government specific jobs in Rajasthan. This is an example. So what have you done? You have given a residential requirement. Resided in Rajasthan can apply for government jobs in Rajasthan. So such kind of law can be made. So saying Article 16 is not preventing the Parliament. That means the Parliament can make any law in regard to employment which has a requirement of residence, which has a requirement that you should stay there, reside in that territory to get this government job. Simple. Then comes reservation for backward. Now we always see that there has to be some reservations for them, that certain percentage should be there, certain number of people of representative should be there from the backward class. So again, the state, so it goes on to say nothing in this article shall prevent the state, that is the state can create a provision for reservation of appointment of certain posts in favor of backward class. Religious and denomination exceptions. Again with respect to religion also, they can create this kind of thing, that if it is a religious particular position, then we will say that person of that religion should only be there in that religious office. Incumbent office of a office in connection with the religious affairs of a religious institution. So let's say there is a religious institution. Okay, let's say there is a Jain temple. Okay, which the government is controlling or under the government control. So they can create a criteria that only a Jain can be appointed employed in the temple, because they will be more familiar with the practices. They will respect, in that way they will have their faith. So it only makes sense to have Jain people in Jain temples for work if it is under the control. Similarly for other religions as well. So this kind is not a discrimination. This kind is fair. They can do it because it has a logical rationale. So Article 16, as we saw, ensures equal opportunity in all the public employment, that is government employment, and prevent any form of discrimination. They have also said that certain kinds do not amount to discrimination, which we saw. Now from here there was a very, very interesting point when we saw Article 16, when it said equal opportunities. So now they started saying that, listen, there has to be equal pay for equal work among men and women. So the government actually passed a law also on basis of this. See what they have said: equal opportunities to all the citizens. So here from that they said that, listen, in the case of Meva Ram Kanojia versus Ames, the Supreme Court clarified that the doctrine of equal pay for equal work. The court said that, listen, now again whenever we say this, we also have to go ahead that, listen, everyone in India is not getting the same pay. So they said a differentiation or a classification done because of the educational qualification, experience, duties, job responsibilities, performance, that kind of differentiation can be made. So it should be just, the point is that it should be fair and open. Okay, unfair and unreasonable and baseless grounds are not allowed. But if I say that, listen, this person was a performer, he got it, so then all this is fair. Then we finished Article 14, we finished Article 16, and now we'll do Article 19(1)(c), which is very simple, that a citizen has a right to create trade unions and that trade union can represent them. So simple. Always you will see that Article 19 always talks citizen, the right of citizen. So this is not available to non-citizens. They can form trade unions and they can form societies, companies, partnerships, all of this. Every kind of association of person is covered. Restriction on the right. Now again, what is a restriction? The normal restriction in 1904 shouldn't be against sovereignty, integrity of India, shouldn't affect the public policy, shouldn't violate any of the laws, etc. Now let's look at a case of All India Bank employees versus National Industrial Tribunal. Okay, so now they are talking about a very interesting thing, that they are saying, listen, you have the right to form associations. So when you have an employer, okay, employer are the companies. Now earlier we had this individual going workman, but now we are having a trade union representing all the employees. So let's say there is a dispute. If, now you tell me, if the government makes a law that, listen, we don't want this disagreement to go on, first you should go through settlement. You should have some talks, some negotiations is required first. So is it fair or no? Or we will directly say that on movement or disagreement, go and go and adjudicate, go and fight in court. So again, whenever there is a dispute, understand one thing, what happens? That there will be a socio-economic impact. Businesses will stop, employee salaries will be stopped. So it brings a big amount of disruption in the society. So therefore, if a law is made saying that you should first try mediation, you should try negotiation, so those are absolutely fair. So this is what is there in these All India Bank employees. they set up a labor union for collective bargaining. They all say now we will collectively see and we'll see what will be done. Okay, now no doubt we are allowing them, but while the fundamental right to strike is there, it definitely causes economic disruption, socio-economic disruption. So they had introduced in the Act, Industrial Dispute Act, they had introduced compulsory industrial adjudication as an alternative to strikes. Directly don't go for strike. There is some measures before striking you have to do. So this is absolutely legal. This is legal and allowed. The substitution of strikes with industrial adjudication is justifiable. So we can say that, listen, we are not saying don't go for strike. We are substituting strikes for some industrial adjudication where some courts, where officers will be there trying to negotiate, closing it, rather than just going and stop work. So if you, it is a good option, this kind of law can be there that, listen, first try this. And if that fails, then you can take steps. Or sometimes they also say that, listen, in case of industries which are very sensitive, for them special rules can be made. For example, the electrical companies or the water companies or employees. So for them, or the banks, for them special rules can be made that, listen, it will create a very huge disruption in the market. Then let's look at this Danyati Narayan versus State of Union of India. The right to form associations also means right to determine and maintain composition of that association. Very simple. Extension. Just because I give you a right to form an association, that also means that you have a right to decide who will be the chairman, who will be the secretary. So right to run the association should also, I should not just allow you to create and not allow to operate. So right to create plus operate is there. Okay. 19.4 can't be justified that, listen, we have a reasonable grounds for opposition and we will interfere with the association's compositions. Who will be the chairman, who will be holding the treasury post, etc. So interference is unfair or unreasonable interference is not as allowed. Now Article 21, very, very, very important, right to life. Right to life is one, they call it as the heart of the Constitution. Okay, always remember, if they ask you which is the heart of the Constitution, you will say right to life, because to life doesn't only mean living and dead internally. Right to life includes having a standard of living, healthy environment, right to education, right to marry, right to vote. So any right required to make life meaningful is given in your article number 21. It says no person shall be deprived. Now again, no person, that means it is applicable to citizen, non-citizen, deprived of his life. You can't take away anyone's life or personal liberty except with a procedure established by law. So procedural laws have to be followed, and then you can take away the life also and put a person in jail or hang to death, all of that, but after a due procedure established by law. Article 21 assures every person's right to life and personal liberty. Life itself is a very expansive meaning. It is the heart, okay, as I told you, it is the heart of the fundamental rights. So two things from Article 21. First is activation of other directive principles. So Article 21 is activated certain other directive principles that, listen, all this should be ensured. Right to livelihood, right to human dignity, right to medical healthcare, right to health. So all of this is saying that, listen, these are the directive principles of state policy. Both are read together. Part 3 and Part 4 are always read together by the legislator. If I'm making the law, I will have to keep the policies in mind. I have to also keep the fundamental rights in mind. So all this I have to ensure. Implied fundamental rights are also there, that from this fundamental rights, more other rights evolve. Now let's see what is this case. of Olga Telus versus Bombay Municipal Association. So there you can write it is about eviction notices to slum dwellers. So slum dwellers were told that listen, sorry, you all are on the road, pavement, leave, get out. We don't know what will happen next, but we are going to take the bulldozer and we are going to crush everything down. So the question was raised that is their fundamental rights violated by not giving them alternative or any means of livelihood, because in that case they were coming on the road and didn't have anything to eat. So I told you fundamental rights are the bare minimum that we have to ensure. So that is getting violated. So does it come under Article 21? Is it violating? So what do you think? So the answer was that listen, you are wrong. You cannot just evict anyone without a procedure established by law. You have to give them some alternative accommodation, some relief. The right to life enshrined in Article 21 is given to all the people, right? Includes the right to livelihood. Any action that deprives the individual, okay, unless a fair procedure is followed by law, then it is a grave violation of Article 21 if the procedure is not followed. So the Supreme Court held that the right to life is not restricted merely by physical existence. That means I'm alive. That's it. Is the right to life? No. It has a broader spectrum that not just physical present. I should be mentally satisfied. I should be emotionally satisfied. All those, and overall talking about quality of life. Okay. So that is why we always tell that enjoy your life. Your life is not about one goal to the other goal to the other goal and not enjoying the process, because at every stage you should enjoy your life. Whatever you're doing, studying, enjoy your studies. Giving exams, enjoy your exams. Enjoy the life as a whole. That is called as a right to life. Now DK Yadav versus JMA Industries. Now what happens in this case? That he was removed from his job in an arbitrary manner without following the process of law, thus violating the rights. So issue involved a termination of an employee's service without giving a reasonable opportunity to defend oneself, without conducting a domestic inquiry in line with the principles of natural justice, is a violation of Article 21. So removing an employee is a violation of Article 21 if the proper procedure was not followed, opportunity to defend himself was not given. Okay, so all of that is needed. Now next is Paschim Banga Ket Mazdoor versus the state of Bengal. So just from here only, Mazdoor means a laborer. Now this is pretty interesting case. This person fell from a moving train, went to government hospital but didn't get any relief. From one place to another he was only running, and then ultimately he had to go to a private hospital too and incurred a cost of 17,000. Now imagine a laborer having to pay 17,000 because he was not satisfied. So does it violate Article 21? So he filed a case that the government hospital failed to provide him the necessary timely treatment. It was held in a classic case that listen, government was responsible. Government's primary responsibility is to give adequate facility, and a failure to do that in a timely manner is viewed as a violation of the individual right to life. Now coming to another very important case. Here they haven't given you anything except just the highlight, where in Vishaka versus state of Rajasthan, you ask any law student, he will know you, that the Supreme Court actually laid down guidelines that for women in workplaces there has to be safety. It should be devoid, or it should be without harassment. The entire guidelines was made, and now you have the Sexual POSH Act also, Prevention of Sexual Harassment at Workplaces Act was made. So here this was a landmark judgment where they said that women was assaulted and harassed at workplace. the Supreme Court said that each incident is a violation of the fundamental rights of gender equality. Okay, it is not only a violation of Article 21 but also Article 14 and 15. Discrimination, right against equality, and Article 21. And on basis of that guidelines, and all the entities have to follow the certain guidelines prescribed by the Vishaka versus State of Rajasthan. Mark it as super important. Now we'll see your Article 23 and 24, right against exploitation. So one is very simple, Article 23, prohibition in traffic in human beings and forced labor. So let's see. First we will read Article 23, 1, sub-article 1 and sub-article 2. Sub-article 2 gives you the exception, when you can. Interesting. Let's see. So first is traffic in human beings. Traffic means buying and selling of human beings as they are goods. Forcing them to beg or forcing them to work is prohibited and punishable under law. Exception. State imposing compulsory service for public purpose, and the state shall not make any discrimination on the ground of this. So this the state can do. Okay, so state can impose compulsory service for public purpose. So this can be done. Okay, in fair cases. Now Article 23, unsocial practices like beggar, human trafficking, forced labor are not allowed. State under certain cases can force a person that, listen, you have done XYZ wrong, go and do this public service. Article 24, very, very, very important, child labor. And we also have the Child Labor and Prohibition Act, Adolescence Prohibition Act. Now the point is, my question, if a person is 16 years old and you're making him work, is it a violation of Article 24? Yes or no? He's only 16 years. Is it a violation of Article 24? You're employing him in a factory. Answer is, it is not a violation, because only those below the age of 14 years shall not be employed in a factory. So below 14 years, if you are making a person work, it is a child labor. 14 and above, there are conditions where you can make them work, for which you have to read the Act, Child Labor and Adolescent Act. And very interesting, this act is not only on government but also on private individuals. So even in a private company or in a private organization also you cannot keep. Now again, a next case called as the Azad Workers case. Now what happened is, there was the Asian Games going on, and in the Asian Games they had employed children under 14. Really stupid, against the constitution. So People's Union of India versus Democratic Rights versus Union of India, and they realized that the core issue was whether you can make a child work who is below 14 under is a violation of Article 24. So obviously whenever there is Article 24, you will mention the Azad Workers case decision. Obviously they have said that it is a violation, emphasize that the right against exploitation is enforceable even without any impeding legislation. So even if there is no law, the courts have to ensure that Article 24 is not violated. Then comes Article 39. Now 39 is talking about directive principles of state policy. When you go to see Article 39, fifth point, it says protecting children from exploitation and giving them a proper opportunities and facilities to develop. So you will write about Article 24, you will write about the Azad Workers case, and you will write about Article 39F. Okay, so I want you to write all this so you can quote it in the exam. Now we are coming to fundamental rights are done. Okay, so if they ask about fundamental rights, you can write all the points we have discussed about. Now we will talk about directive principles of state policy. Very, very simple. The directive principles of state policy are from Article 36 to 51, Part 4 of the Constitution. What is the objective of the directive principles of state policy? Understand one thing. The directive principles of state policy are not enforceable in court. You cannot go and tell the court that, listen, I have not got this directive principle of state policy. Its purpose is to give certain principles which the state should keep in mind while making the policy. It is a policy guidance. It gives you the most ideal things that we have to achieve. Fundamental rights give you the most basic, whereas this gives you the most advanced things that we should give. So obviously we will try to do it. Okay, with time we will achieve it. Constitution framers have recognized the need for economic democracy alongside political democracy. They added the provision to improve the social economic condition. So it is not, as we have thought about freedom, economic freedom should also be there, and prosperity. So these principles, the directive principles of state policy, actually promote social and economic democracy. The people should be rich and live. Integration with fundamental rights. So I told you that fundamental rights are violated. Basics ones are not given, you can go in court. But if the top one, that directive principles, are not violated, you cannot go in court. But always whenever state is making, they will keep both part 3 and part 4 into line and then make the law. Now it is time to look into the depth. What all are the article numbers that talk about labor laws and directive principles? Okay, so we have these Article 38, 39, 41, 42, 43. Very, very important. We will see each one. 38 we will start. Social order based on social economic justice. So let's read. So this we are seeing is directive principles of state policy. Article 38. First, point 1. The state shall strive to promote welfare of the people. So objective is that we have to do social welfare. Article 38. State shall secure a social order for promotion of welfare. So it is the duty of the state to work for a social order, that in the society there has to be some discipline and where welfare of everyone can be done. And second is how welfare will be done. The second point is we will try to minimize income inequalities. Because if you go to see, it's not only in India but worldwide, 1% of the people own 99% of the wealth of the world. So we have to ensure that, at least those who are extremely below the poverty line, we have to just get them where they can have at least a minimum wage should be available. So we will see all the articles which are there. Social economic justice. First we start with article number 38. We read, even in the constitutional preamble they talk about economic, social and political justice. Now article fundamental right to health. So this was in this case under the Consumer Education and Research Center Union of India. The Supreme Court emphasizes the right to health and access the medical care is a fundamental right. So these article numbers you have to write, few case laws you need to write. Article 38 read with 39. Article 38 is always supported by Article 39. So now we have to see what is Article 39. 38, what was 38 talking about? Social justice. And 38.2 was talking about no discrimination. Now we are talking of Article 39, which is actually directive principles of state policy, that the state shall direct its policy towards, they will give you giving equal livelihood, okay, common good, resources should be available, wealth should be fairly distributed. One interesting point they have given you is the point: equal work for equal work and equal pay. that the health and the strength of the workers, men and women, and children, no child abuse, child labor, children should be given an opportunity to develop. So you can see these points. Article 39 you can write, mostly talking about how social justice will be there. Now every time I have told you equal pay, equal work, is it a fundamental right or a constitutional duty? I am asking you, you have to tell me. Is equality of pay, equal pay, equal work a fundamental right? Obviously not. I am teaching you directive principles of state policy, that is part 4. So it is not a fundamental right. It is a constitutional duty put on the states that listen, try to give equal pay to equal work. Not a it is not in fundamental right? It was not in the initial part of the lesson. It is from Article 39 where we are dragging this point, right? Article 39, which talks about equal pay, equal work. So you have to write that as per Article Part 4 of Constitution, Article 39D talks about equal pay, equal work. So it is not a important. They can ask you in the exam. It's not a fundamental right. Okay, no person can go in the court for this. In the Randir Singh versus Union of India, the Supreme Court establishes that while equal pay for equal work may not be a fundamental right, it is undeniably a constitutional objective or constitutional aim. We want to achieve this. Applicability to daily wage workers. Now again, it is even applicable to daily wage workers. Very simple, that everyone should also get equal pay. Even if I'm working on daily wages, discrimination should not be done. Discrimination should not be done with, person is working daily, person is working in permanent place. Why? Because we are saying equal work, equal pay. Flexibility in application. So again, we have seen this, that if you want to do on salary discrimination, but on reasonable grounds such as education, background, your status, your position, then it is fair. The CEO doesn't get as per the watchman, right? So again, next, very classic case of daily wage. What happened is they were not giving them same salary as their permanent employees. So in Dhirendra Chamoli versus State of UP, what happened is daily wage workers were not getting proper salary as but the work was same. Okay, so the employees, so then again it was said that it is wrong, you have to give them same salary if it is same work. The employees were engaged in different kendras in India. The employees were informed that they would be paid daily wages, but would not receive the same salary and benefits as class 4 employees. However, they performed the identical duties. Issue involved whether this is violating Article 14. So Rule 14 says you should not discriminate, and this is also coming in your implied Article 14, that we are extending the right to life is being affected with this part. So the Constitution conclusion of this case is that equal pay for equal work is a constitutional mandate. Employees engaged in similar duties should receive similar compensation regardless of the employment terms. So again, the Supreme Court has said that it is a constitutional mandate and constitutional duty, not a fundamental duty because it's not there in Part 3. But definitely from Part 3, Article 14, we are extending it and saying that to this case, and they said that equal pay for equal for this. If you are not doing, then it is violating Article 14. So it is a implied power of Article 14 is being dragged here. Next is again a very simple case of the building construction workers. National Campaign of Committee of Central Legislation versus Union of India. Facts of the case. Now again, there was a law called as the BOCW, okay, Building and Other Construction Workers Act, which gave a lot of benefits to these workers. The company did not implement it only. So since this beneficial act is not being implemented, it was a violation of Article 30, 15, 13, 45 and 47. Okay, so the rule laid, or the conclusion was that if these acts were of benefits for the workmen and it was not followed, so therefore it is a violation of Article 21, right to life. Human rights and dignity of building and construction workers must be respected, and the avoiding this act is a violation of the Part 3 of the Constitution. So we see in multiple cases they are extending that it is violating the fundamental rights. So extension is being taken, and we are realizing that if you are not following welfare legislation like the Building and Construction Workers Act, then you are violating this. So the court ordered the company that these acts are for safeguarding the dignity of the construction workers. They must be implemented in order to bring in social and economic justice and adherence to rule of law. Next, in Bandhu Mukti Morcha versus Union of India, facts of the case that employment of children in industries is violated of constitutional provision. Obviously, yes, we've seen that, and it is violating Article 24 for sure, and at the same time Article 39E and 45 of the Constitution. The court directed that the government to develop policies for progressively eliminating child labor. So we have an act also now, the Prohibition of Child Labor Act, and also to give them compulsory education, health checkups and certain benefits. Then we see a concept of social security. Now, if I tell you what do you mean by social security, the word itself, social security. So, if you go to places like Canada, there is a concept of social security which is implemented there. That is, if you have if you are unemployed or you have retired, this government will pay for financially supporting you. In Indian Constitution also, we have in the directive principles about social security. So we will see the articles, and it's a very nice concept, and we can say that a country has truly developed on basis of the social security provisions that they provide to their citizens. So social security is a government program which is designed to financially support individuals in the time of retirement, unemployment and disability. In the Constitution of India, under Article 39, 41 and 43, social security has been guaranteed. Social security provisions is an integral part of a welfare state. This I agree, and even you will agree that these kind of measures are needed for a welfare state. Let's see the articles which are there. These are all in your directive principles, where the state will try to ensure that these things are provided to you. First, we start with article number 41. Article 41 says, now you will be shocked that in the Constitution we are mentioning about social security, that the state shall give assistance in case of unemployment, old age, sickness, disablement, and in other cases of undesired deserved wants. So you have very socially disadvantaged, and you have to do things which you don't have to want to do, or you're not able to meet it, then the state shall, from whatever economic capacity they have, they will try to provide this for the citizens. Then comes the directive principles, article 39, that the state shall guide its policy to give a livelihood, adequate sufficient means of livelihood. Article 43 says about a decent standard of life and a living wage. We will understand what is a living wage in some time. It's a very important concept. And we have social security provisions under the Indian labor laws also. We had State Insurance Act. In the case of sickness, injury, maternity, they used to get insurance. The employers used to take this insurance whenever the employees were sick, injured, or having maternity, they would get this insurance. Then also we have provident fund. At the time of retirement, they get a certain lump sum amount. Maternity benefits in the case of you could say your pregnancy, these benefits were given. You had gratuity at the time of retirement. All of this is now covered under the labor codes. In training also, they have the Apprentice Act, that when you're training, when you're hiring an apprentice is not an employee, they are an intern. So when you are keeping these on-job trainings or these institutional training programs, so there are apprentice, so there are acts that you have to have contract, you have to give them sufficient remuneration and not exploit them. There is also a law which is employment exchanges, where the government will keep a record data of vacancies that are there and notify to all the job seekers. Then working conditions. Now again in Article 42, they say that the state shall make provision for securing just and human conditions of work and for maternity relief. Supreme Court, while interpreting Article 21 in conjunction with Article 42, has expanded that it is the right to live with human dignity. A right to life includes a right to work in healthy environment as well as get maternity benefits. This is the Article 42 is the basis of labor laws that obtains in India. Large number of labor laws that are there, because we all try to give them just and human benefits, and Maternity Act is also there which provides them huge amount of benefits. Then you tell me, this is a very important concept and it will come multiple times in the exams. One is, what is a minimum wage and what is a living wage, and what do you want? So a minimum wage is the bare minimum which a business has to pay its employee. If they cannot pay the bare minimum, they should shut down the business. Whereas a living wage is giving a wage sufficient to live a happy life with a good standard of living. So now you tell me, do you want living wage or minimum wage? Obviously anyone would want to have a living wage. Now what is the living wage and where it is given? So first thing is, living wage is given in your Article 43. Living wage for workers. It says that the state shall endeavor to secure a living wage, that is a decent standard of living for all its employees. Article 43 states ensure that living wage for all its employees and guaranteeing its citizens a standard of life. The obligations of Article 43 is just not satisfied with minimum wage. It does not say you have to give minimum wage, but are entitled to living wage. So let's understand the difference between living wage and minimum wage. Living wage is which provides a person and his family not only the bare minimum, but also education, protection against ill health, requirements of social needs, insurance, etc. A minimum wage is just sufficient to compare the bare minimum physical needs of a worker and its family. In Edward versus Ajmer, it was held that fixation of a minimum wage is in public interest, does not impose unreasonable interest on the right to carry on the trade guaranteed by Article 19(1)(g). What does it mean? So the government provides for minimum wages. So what happened is, they said, listen, is it violating Article 19(1)(g), the right to do business? Business is from owner point of view and this is from workman point of view. Business owners are saying, how will we pay? We will not be able to run the business. So is it interfering with Article 19(1)(g)? Answer is no. It is fair and it is not unreasonable to keep a minimum wage, it is not affecting with a fundamental right to do business and interfering within the business on how much you should pay the salary. Then comes workers' participation in management. Now you tell me, normally, do you think that management, board of directors will listen to workers, what they want? So here we are saying, listen, Article 43A. 43A says that we should get workers' participation in management. We have to encourage them, let them speak up. Okay. The state, so the Article 43 is talking about participation of workers. The state shall ensure, take steps or make some legislation to secure the participation of workers in the management of the organization. It was introduced in the 42nd Amendment, where they wanted to emphasize the role of workers and expand the workers' roles. It underscores, it underlines or highlights or emphasizes the importance of their voices also in the decision making process. Now in Jana Paradi Surya Narayana versus Municipal Administration, facts of the case, the main grievance was inadequate pay they paid for despite full-time working hours. So there was a case, this is a very interesting case, where part-time workers were made to work full-time, but no full-time wage, no proper wage. So let's see, what was the issue involved? Whether the petitioners who were working 8 hours a day are entitled to equal pay. Okay. So decision held that when part-time workers are regularized to full-time workers, they should be given minimum scale as per their this, and discrimination should not be done on basis of full-time and part-time just because they were hired part-time. But now since they are made to work full-time, they should get similar pay, and not giving them full days pay is discriminatory and violative of Article 14. And that is it. We've completed with the entire chapter and all the articles of the Constitution. Thank you.